Good afternoon, everyone. I am Brianna Rossa, the Office and Events Coordinator for here at the Small Business Center. And today we have Caroline. She is from the Canadian Intellectual Property Office. And she's here to discuss with us today why intellectual property matters to your business. So this workshop will go over trademarks, patents, trade secrets, industrial designs, copyrights, and explain how to protect your creations through IP. Rights can give you the advantage over your competition. And I will now pass it over to Caroline.
Thanks, Brianna. So hi, everyone. I think I recognize some name. I think I've spoke with one or two people in the group, so that's great. So as Brianna mentioned, I'm here to talk to you about intellectual property, IP. And my title with the Canadian Intellectual Property Office is I'm an IP advisor. And as such, I deliver training sessions such as this one. And I also offer one-on-one sessions. If you would not mind okay, thank you so much, and turning off the mic. Okay, so I offer one-on-one sessions for you to better understand what is IP, because just be conscious of the fact that information related to IP before you file for protection might have to remain confidential. So if you're asking questions through this presentation or presenting a business case or something, just make sure you remain very vague so you don't waste your chance of maybe getting IP protection later. There's something else oh yeah, and you can please ask your questions as we go, either by using the chat or by unmuting and raise your hand. I only see 3 people here, so I know there's a bit more for the presentation, so don't hesitate to interrupt me. Getting questions as we go allows me also to readjust and making sure that everything is clear and that the concepts are crystal clear for you. I see there's a question here. Please okay, perfect. So that's Brianna. Perfect, Brianna. Thank you so much. Okay, so let's start. What we'll do today is I'll explain you very briefly what is the role of the Canadian Intellectual Property Office, CIPO. And also after is why intellectual property matters. Why is it important as for an innovator, for a business person, for an artist, a creator? Why is it important to build the appropriate IP portfolio? Then we'll jump into the different types of IP and some tips and consideration while developing a product or service. And we'll conclude by explaining or listing the resources that CIPO, Canadian Intellectual Property Office, offers for free. In fact, today's session is offered for free, same as for the one-on-one sessions that I do offer. So quickly, CIPO belongs to Innovation, Science and Economic Development, formerly known as Industry Canada. And the main mandate of CIPO is to grant IP in Canada. So we have teams of examiners that receive applications for patents, trademarks, industrial designs, and copyrights. And depending on the right that is being sought for, there's an examination that is either very short or very complicated and tedious. So at the end of the process, IP is granted, and it's for Canadian and for foreign applicants as well. I'm not an examiner, and nor I'm not a lawyer, so I will not provide legal advice. My role is highlighted, let's say, in the green, in the middle of the slide, the green one, to build IP awareness and education. So I don't provide legal advice, as I say, but my role is really to discuss your business objectives, what you're developing in terms of product and service, and to identify the proper or the different options that you have to protect that project, let's say. So quickly, these are the types we will cover today. So trademarks, patents, copyrights, industrial designs, and trade secrets. Why are they important? Knowing about IP, knowing about what you're developing for sure, but what your competitors have will help you, or what exists on the market will help you making costly mistakes, what they could be. You're planning or you intend to develop a new technology, a new feature on a cell phone, a more performing tool, whatever it is. Well, searching in IP databases, which are available for free, either patents, trademarks, industrial designs, copyrights, will give you an idea of what exists out there. And you will know, is it, okay, does it exist? Yes or no? Or is it patented? So in that case, you're developing something that you know there's a niche, there's a need, and nothing exists as such on the market. So doing this, it will provide you with an edge over your competitors. You're the first one to launch such products, such service, or you're improving something that exists and is very popular on the market. So you're building, at the same time, you're building your reputation on that market. So doing this, doing the proper research, working with the relevant professionals will place you, would position you in those markets that are important to you. And doing all this, it will help you obtain financing. More and more, banks and investors will rely on an IP portfolio, will attribute a value to an IP portfolio, and they will provide funding based on that value. And more, federal and provincial government, when they provide funding for, especially with innovation programs, they will ask for an IP strategy. They will ask you to submit an IP strategy. And don't be afraid, it's not a 25-page IP strategy. It's more like to demonstrate that you've thought of an IP strategy. So planning to file for patent in Canada and the States, probably using trade secrets, or filing for trademarks for my new product, my new service. So that's what they were looking for, at least to know that what you're developing, what you're launching will be protected on the markets. So doing all this, making sure that what you're developing does not exist, that you're at the edge, you're better than your competitors, you've obtained financing. And by thinking of developing a strategy is, okay, what am I developing? What am I offering? Where are my markets? So you decide that, okay, my markets would be Canada and the States, and maybe some countries in Europe and maybe in Asia. So you identify those countries that are as interesting and lucrative for you. You will secure your IP in those markets, and then it will help you achieve your business goals. The example I use when I talk about securing your markets and being strategic, because there's a cost attached to IP protection. Think of a company that develops technologies that are winter sport related. So in that case, to be strategic, there's probably patents, trademarks, and industrial designs involved. To being strategic, we'll say, like, you will not file for IP protection in all the countries in the world. First, it's way too expensive, and there's no need to file in countries where there's no winter sports, unless you manufacture in, let's say, Mexico or China. So let's say you identify 6 or 7 countries, Canada, States, France, UK, Germany, Finland, Sweden, let's say. So you will file protection in those countries where you know you have a client base, you have distributors, you have manufacturers, and you have people to monitor the market. And we'll get there eventually, but you also have to be aware of the fact that holding IP rights comes with homeworks. You are the one responsible for monitoring counterfeiting infringement on your IP. CIPO or any other IP offices around the world do not monitor for infringement. So that's why also being strategic is also filing where you can monitor your IP. So having done all this, developing new products, new service, obtaining financing, securing your markets, being present on those markets, with time, you will build your reputation and your goodwill. And then potential partners, clients, collaborators will be a lot more inclined to work with you. I'll give you an example also with obtaining financing. You've probably watched Dragon's Den or Shark Tank in the past. And investors will often ask participants if they've protected by trademarks or patents. And the reason behind that is IP protection provides exclusivity in the market. So a trademark that's filed in Canada will protect you all across Canada. So as an investor, the project becomes more and more interesting because you have the exclusivity, you have the right to decide to select who will use that trademark for you across Canada. If it's not protected, it means it's open to the public, so anyone can use it. So as an investor, it's not as interesting as that exclusivity that IP protection provides. Is there any question before we jump into defining all the IP rights? I don't see any question, but I'll just pause for a few seconds to give you a chance to raise your hand or use the chat. So far seems okay. Oops. All right, so we'll start with trademarks. Anyone has an idea, and use the chat or unmute, any idea how many trademarks you see in a day? Do you have any idea? Two? 50, I see 2, I see 50, I see 10. Well, what about 1,500? Think everything around you has a trademark. It may or may not be registered. Think of clothing, food, beverage, cell phones, cars, appliances, everything has a trademark. So we're surrounded. So what is a trademark? It's a sign that differentiates your product and service or service from your competitors. So think of Coke, Pepsi, Honda, Toyota, Starbucks, Tim Hortons. And in selecting one of these companies over the other is not a bad decision. It's because as a customer, you attach a sense of, how could I say this? You attach a well-being with this company. Like, let's say you love Starbucks coffee because you like the experience, you love the food that goes with the coffee. You're used to, we'll go back to Starbucks to travel across Canada and the States. You will stop at Starbucks because you know what you're getting as an experience. So having a trademark in Canada, as I said earlier, will provide you with an exclusivity to decide who will use your trademark. So Starbucks is a good example. When someone acquires a Starbucks franchise, they cannot brew any kind of coffee. They cannot offer any kind of whatever they have, muffins or croissant. It's what Starbucks has to offer. It will be offered at that premises. And in Canada, as I said, it's a mix of automatic use and registration. So not all trademarks are registered. For example, and we'll see in the next slide or two, some trademarks, because of their name, are not registrable. However, if your trademark has a potential to be registered, it's highly recommended because it protects you all across Canada. A trademark that's not registered is only locally protected. So let's say in Belleville area. And it's more complicated to prove the use or the start of use of a trademark if it's not registered officially at CIPA. And in Canada, a trademark is valid for 10 years. And it's renewable as long as you use the product or the service, and it's renewable every 10 years. And to file for trademark, it starts at $340. And not to go into the details, but it includes one class of product or service that you have to identify as being used under your trademark. Should you have more than one class of product and service, the cost will increase by $100 per other class, but that's very technical. So I don't want to spend too much time like right away, but if you want, we can elaborate later during the presentation or after. So I said, not all trademarks are registrable, and this is mainly something to consider when building a trademark. Descriptive marks are not recommended and are very hard to register. because they're considered being weak in the sense that, let's say the trademark is, I don't know, it's a bakery and you call it Joe's Bakery, okay? It's too descriptive. It says that Joe has a bakery and selling under like baking goods. And it would also give Joe the exclusivity of the word bakery across Canada. So we try to stay away from descriptive marks. Personal names are not recommended either for the same reason. We don't want to give someone the exclusivity on a name when there's plenty of other people using the same name in Canada. When it's starting to get interesting and much more registrable is when you're going into suggestive marks. Let's say chapters for books. Of course, one could argue that books are made of chapters, but chapters is not selling chapters. They're selling books. They're selling candles, cushions, blankets, etc. Anything that's related to cocooning and it's around reading. So you see the logo, you see the book. Okay, you know now it's a bookstore, but it's not descriptive. Using a dictionary words that is not related at all to what you're offering is also very good. Apple for computers, telephones, etc. Roots for clothing, Indigo for books. Like with time, those brands have gained so much notoriety that we know exactly, as soon as we see them, we know exactly what they're offering. But right at first, it was not a clear association of what they're offering. So that's why we say dictionary words are really good, because they kind of attract people's attention. And the last one you can consider is coin terms. So inventing a word for your product. Then you're pretty sure that it does not exist and it's not confusing with any existing marks on the market. So Kodak, Kleenex, Polaroid were good examples through time of invented terms for trademarks. How to make sure that the name you have in mind, especially if you're using suggestive or forgot a word, or a dictionary word, are not already protected. You can search the trademark database at CIPO. It'll give you the trademarks in Canada. And it will also give you, when I said it, you have to associate with the product or service you're offering. So we call them classification of Nice classification from the city in France. So it'll give you numbers, and that's a class it's attached to. So let's say, I don't know, whichever name you have in mind, and you're offering, I don't know, my imagination is failing me today, but let's say you're offering cleaning services. I don't know the class, but pretend it's class 15. And you see the same name you have in mind, but it's for a restaurant. Chances are you could have your trademark because it's not confusing to the clients. They will not direct themselves to the other service if they're looking for house cleaning services. They will not go to the restaurant. So that's an examination and a reflection you have to make when selecting a name. Something very important, especially now, it takes a while now to get a trademark registered for different reasons, including lack of staff. Like everyone else, we're understaffed. So when I started CIPO about 15 years ago, it was 12 to 15 months to go through the entire process. Now we're looking at 3 years. But don't despair. It doesn't mean that your trademark is not protected, because first, it's protected as soon as you start using it. And as soon as it's in the database, it says to the world or to Canadians that, hey, I've got my dibs on such a trademark. So please try not to use it. And if you're looking at a 10-year protection, let's say you file today, and in 3 years you get a final decision as it's, yes, it's registered. Well, the renewal of the trademark will be only 13 years, not in 10 years. So that's a plus. So owning your trademark will first gives you the right, of course, to use it, but also to decide to get into partnerships and to grant licenses to other people across Canada to use the trademark under your standard of quality. So it's not a bad thing. Again, think of the Starbucks, think of any franchise you know. Wherever you go, they offer the same kind of service and quality. So having a trademark will allow you to either sell your product or offer your services across Canada and under your banner. Something important to remember, a business name, if you're incorporated, it's not a trademark protection. It's two different entities. Same with a domain name. So see those three, the business name, the domain name, and the trademark has three different ways to protect a different aspect of your company. Your internet address, your legal entity, and let's say your marketing identity. So in terms of marking, when your trademark is not protected, let's say you filed and you're waiting for a decision, you will identify it as a TM, trademark. And once it's registered, you can use the circle R. So that's just, and so from now on, that will give you an idea of, okay, is this mark registered or not? Not that it means that you can or cannot use it, it's just that it gives you an idea of what's the status of this brand. I think, yeah, before we jump into patent, is there any questions on trademarks? I'll give, so it's either you're completely lost or you're falling asleep, or it's quite crystal clear what I'm saying. I see Eric saying yes, okay, perfect. I'll keep going. So patents. Patents will protect a functionality, will protect a technology. And to get patented, an application must meet three criteria: novelty, usefulness, and ingenuity, non-obviousness. Good thing is improvement on an existing technology is patentable as long as it's deemed novel enough, useful enough, and ingenious. Novelty, I would say, is pretty easy to demonstrate. Does it exist? Yes or no? Usefulness, again, fairly easy to determine. Does it solve a problem? Where the patent process is very long, tedious, is probably around that third criterion, like the non-obviousness, because it's either you file on your own or you're filing and you're hiring a patent agent. Patent agent or yourself will negotiate with patent examiner to determine the scope of the non-ingenuity. And again, it's a long, tedious process, but as an applicant, your patent agent will try to protect, to get a protection that is as broad as possible on your technology. And together with the patent examiner, they will, okay, at the end of the process after negotiating, the patent that will be granted will be strong for you in terms of legal protection, but also technical, mechanical. So that negotiation might seem very complicated and complex from the outside, but it's to making sure that whatever patent is granted is solid on the market and, as I said, on the legal side. And again, having a patent is a right to exclude others from using, making, or selling your patent, or granting, or you can decide to grant the patent to a company A versus a company B. As I said, the application and process is fairly complex. It could last from a couple of years, a few months to a couple of years, depending on complexity of the technology. And also SIPO, we do have mechanism to expedite some applications. If your application is in the green technology field, it can get expedited at no cost. And I think to this day, it's still the case, but for any COVID-19 related application, it also can get expedited. Your patent will be granted for 20 years, but from the date of filing, not from the date of granting. So it makes a difference. And I spoke about novelty, so which means that it has to be new to the world, not only in Canada or wherever you file for your patent. So you have to make sure, making research and do a lot of research. But should there be any disclosure of your invention prior to filing? So let's say you spoke with someone and they did not respect the non-disclosure agreement. or you participate in a trade show without knowing that you have to keep a secret, whatever it is, whatever the circumstance. In Canada and the States, if you disclose your patent or invention, you have 1 year to file, and you can benefit for 1 year, what we call the grace period, to file for patent protection. Be aware though that in Europe, it's zero tolerance. So if you were planning to file for patents in Europe, it's unfortunately game over for you. Other countries such as South Korea, Japan, Australia, South Korea, China, Australia, have also some kind of flexibility depending on the circumstance in which the information was disclosed. But by and large, if you are developing a technology, be mindful of the fact that it has to remain confidential. Make sure you have the appropriate non-disclosure agreements, confidentiality agreements, while discussing with anyone else. If you and I meet, consider it secret because I'm bound by secrecy because of the nature of my work. But if you have to look for manufacturers, potential distributors, make sure you have those agreements. And word of wisdom, if they refuse to sign a non-disclosure agreement, maybe don't discuss with them because you never know. So again, we have databases, Canadian, we have an American database, there's a worldwide patent database, but also do research on the web, read the scientific literature, you know your field, so you know who the big companies are, you should have a good idea of the state of the technology in your field. And as I said, hiring a patent agent is probably a good idea. It's fairly expensive. So there's a lot of work you can do prior to hiring a patent agent, but that patent agent is an expert in the field that you're in as well. And the examiner at the end of the process, be it at CIPO or anywhere else in the world, is also an expert of the field. So those two experts will be negotiating, agent representing you, your interest, and the patent examiner representing public interest. So again, as I said, it's for at the end of the process, the patent that is granted is solid and represents what you're offering. And as I've mentioned, any improvement of an existing product could be patented. And word of wisdom, don't disclose unless you really, really, really have to, or be conscious of the fact that you need to have those agreements signed before you start talking and discussing, negotiating with other parties. This is more technical. Okay. When it comes to patent, we have to differentiate inventorship and ownership. Inventorship is who has worked at developing the technology. Who are the inventors and co-inventors? Those people may not be the owner of the patent. If you're developing a technology in your house or alone, okay, and you're self-employed or you're doing this in leisure times, whatever it is, it's yours. You'll be the owner of the patent. You'll be filing for patent protection. But if you're working for a company and you're hired to develop new technologies, the patent will be owned by your employer, although they really have to mention your names and all the co-inventors. Otherwise, you can invalidate a patent. I said there's a lot of work you could do prior to hiring a patent agent. A patent application is composed of an abstract and a description. You're the inventor. My suggestion to people is always write a description, write the abstract. Worst comes towards, a patent agent will just fine tune and, maybe adapt it to a more like application format, let's say. But there's a lot of work. Do the search and just have the patent agent validate your research. Something very important to mention also is all countries in the world, when you file for a patent, it's a first to file system. All countries in the world. So even though that's the importance of the non-disclosure, if you disclose your information and someone in the room understands exactly what you're talking about, they can file for patent before you, and you would have no right on the invention you've developed. So that's why we say don't disclose. It's crucial. It's the name of the game when it comes to patents. Any questions on patents before we move to trade? Yes, Brianna?
I do.
Yes.
So if you sign a confidentiality that if you have a conversation with somebody, that would be a breach of confidentiality, would it not? If someone told you something within confidence and you have signed a confidentiality sheet, that would be okay.
Yeah,
just
absolutely.
wondering if that was any different. Just curious.
And it's also, let's say Brianna and I were negotiating and we do have a confidentiality agreement. And for some reason, I become very mad about Brianna for some crazy reason. And I just disclose information and I go on about and I start, talking about invention and filing for patent and whatever it is. Brianna could sue me, but the recourses are fairly limited because I'm not a large corporation as a starting point. And the fact that the secret is disclosed, she can sue me, but whatever damages she can get or money she can get will never be as important as the damage that I've incurred to the reputation of the company or to Brianna herself. So think of it before negotiating with someone. When they're larger corporations, it's easier because we know them, they have a reputation. But if you're talking with individuals, do your research, do your due diligence, get information, ask them for reference. You never know, because you could lose your project. And that's the last thing you want, is to lose that project you're working on for years, and you want to make sure that you're doing the right thing. So do your research and limit the damage as much as possible. So now that we've talked about patents, when you file for patent, it's a full disclosure of the invention. So someone versed in that field will understand exactly how it works and the mechanism, and they can improve on it, which is okay, because if they file for, let's say, an improved patent on your own technology, and again, it's also technical, but let's say they file for patent generation 2, let's say. But to have the right to operate their patent that uses a lot of information taken from your own patent, they will have to obtain your consent to exploit their patent, because they're kind of playing in your field. So in exchange of royalties, you will grant them freedom to operate some parts of your patent. So the patent is not only a protection tool, it's also a commercializing tool. And it will help you increase your revenues, because the information you've disclosed is interesting to other parties, and they will need them to operate their own patent. A trade secret in exchange is any information that must remain confidential, either until you file for patent or industrial design or trademark, or for the duration of your activities. Think of the Coca-Cola recipe. This recipe has been kept secret for over 100 years. We know the ingredients, but I don't think anyone around this screen could make Coca-Cola in their basement and have the same exact recipe. So part of the value of the trademark of Coca-Cola relies on the strength of its recipe, the secret. So especially if you're talking about long-term trade secret, it's tied to your capacity to keep it secret and to make sure that no one or very limited people have access to it. So there's no registration. We don't have a database of trade secrets, obviously, at SEPO, and it's a contract between the parties that have access to the information. And having a contract to protect the trade secret, this contract has to be as strong as possible and has to anticipate any problem that could go wrong. So you have to expect the worst, but hope for the best and expect the worst. So have all the clauses agreed upon by the different parties, and making sure that everybody is agreed to them. Should you get legal support on this for trade secret? Yes. What I suggest to people is, again, internet offers a lot of templates. Make sure they are from Canadian firms, so they are according to the Canadian law. So draft a contract, and after that, have it validated by a lawyer. But again, if you don't want to spend time writing and searching, you can hire a lawyer that will draft the contract for you. It's always a matter of balancing time and money and effort that are all required. So obviously a trade secret has no limit until it's disclosed, obviously. Perfect, thank you, Elizabeth. So yes, so the secret will be, well, the protection is maintained as long as a secret is maintained, obviously. So do not disclose, make sure you don't, even people you think you fully trust, don't do it. Because it's part of the game. What if someone is not well-intentioned and they go about and they disclose the secret? Then it's done and you have no protection, especially talking about technology. If someone reveals the technology, you cannot get a patent because it was publicly disclosed. So it's just be conscious of that. So to keep a secret, agreements, obviously, hiring people, making sure that in their hiring contracts and exit interviews and whatever exit part of agreement that you might have, that they will not disclose any information. Encryption, of course, password protection, of course, just like traditional lock, safe and with a lock and a key, and limit people that have access to the information. That's crucial to maintaining a secret. Any questions on the trade secret? So I'll keep going on in industrial designs then. So if a patent is all about functionality, industrial design has nothing to do with functionality. It's all about visual aspect. It's a shape, it's an ornament, it's a pattern, a configuration. So look at the Coca-Cola bottle, which was very interesting because it was designed in 1915, as it says on the slide. And at the time, any liquid that was sold on markets, they were all in those sort of square-shaped bottles that would be amber, green, or blue, depending on what you were selling. And Coke decided to be innovative and develop that model that we still see today and we recognize today. You see that bottle without a logo on it, you know it's Coca-Cola. So what they did is Coca-Cola protected it by industrial design at the time, 1915. And let's say at the time it was 10 to 15 years protection. Once the protection was expired or was getting expired, because the shape has gained such notoriety on the market, you would recognize the bottle, you recognize the shape, you know it was Coca-Cola. Coke transferred the protection, the initial design protection, as a trademark. And that's something that could be done. If the shape you have protected as an initial design has gained notoriety on markets, you can convert it into a trademark. And the strategic value of that is because you can renew your trademark protection every 10 to 15 years, depending on the country. While it kind of still to this day in 2022, we're still drinking Coke in that bottle and it's still protected because they had the strategic vision of protecting it as a trademark. Other shapes that come to mind that are protected are the Toblerone chocolate bar, the Perrier water bottle, the Orangina bottle, and I'm sure if you look into perfume bottles, most of them would be protected as a trademark. Those that are, let's say, more than 10 to 15 years. And again, having a visual design that is protected will give you the right to exclude anyone from using it, unless you grant them permission to. Let's say you're a designer and you've designed a new armrest, okay, on your chair. Well, you might sell it, or you might give a license to manufacture and to sell to transport companies, to airlines, to chairs that are designed to doctor's office, whatever it is. So you can have different clients using it. So you providing a license to use to different entities, different companies. So hence you're increasing your revenues. In Canada, the industrial design, pardon me. In Canada, your design will last for 15 years for the date of filing, not from date of granting. And again, and as I said, could be converted into a trademark after. And same for a patent, there's a 1 month grace period in Canada and the States if the design was disclosed. Think of all the school, universities or colleges offering industrial designs. They have exhibition at the end of the year. And so students are really happy and proud to display their designs. Well, it's a risk of being copied. So if that's the case, recourses are possible, but it's very complicated. So same for patents and trademarks. You can do research on different databases, Canadian, United States, Europe, worldwide. Again, nothing about functionality. It's all about the look, and it must be original. One example we give when we delivered the sessions on industrial design is think of an electric toothbrush. If the button is on top and you design a new one with the button on the bottom, it's not original enough. It will be much more original to get granted a second industrial design on the toothbrush. And as I've said, you can convert your industrial design as a trademark, distinguishing guys at the end of the protection. Any questions? Okay. So I'll keep going with copyrights. Oh, I see there's a question. My business is woodworking. I make charcuterie cutting boards. Do I need a trademark? Well, it depends. It's all up to you. I'm not there to say, yes, you do, yes, or no, you don't. If you have a really cool name or logo or tagline that you want to protect, absolutely, you may want to protect it. So what I suggest you do is you will get a copy of this presentation and you can contact me and we can have a side conversation, but it really depends on your strategy. If you're planning to sell very locally and there's no other strategy to expand the business across Canada, or you may not want to spend money protecting your trademark, but it all depends on, as I said, your business strategy. So I suggest you contact me and we'll spend some time together to discuss potential options. Copyright protects any original work. So from a book, computer code, website content, a blog, a song, a musical, anything. And it's the right, it provides its owner the exclusive rights, but also right to decide who will perform, reproduce, and publish the work. Copyright is automatic upon creation. So let's say you have a website for your company. Protection starts as soon as it's public. And it protects you in 156 countries in the world. However, what is suggested is you register the copyright for $50 at CIPO. And the benefit of it is, should any company copies your website, and they're just ignoring your cease and desist letters, your request to stop copying, and you decide to go into litigation. When you go into litigation and in court, your certification will be the proof that you're the owner of the work, not the plagiar, the person that copied your work. And in Canada, and it'll be changing fairly soon, but for now, the copyright is valid for your life plus 50 years. So it's a good deal. Let's say you wrote a book and I don't know, let's say you die in you die in 50 years. Well, 50 years after the copyright will be expired, and then your work becomes public domain. This is how they play a lot of Molière and Shakespeare in schools, because they don't have to pay copyrights to play them. So as I said, it's $50. It's very easy to do. We don't ask for a copy of the work. You just submit the title and let's say if it's a website, let's say company blah blah blah.com website content. That's it. Regardless of the fact that you've submit for copyright protection, always mark your work with the circle C, your name or the name of your company, and the year of production. I always suggest to ask all rights reserved, or copying of this material is not allowed unless without the consent of the owner. So just to make sure that you tell the world that the work is protected. The fact that the first author of the work is not necessarily the owner of the copyright, I'd like to extend that to all IP rights. In Canada, under the Labor Act, any work performed and generates IP, the IP belongs to whoever pays the person that develops the content. So you're hired to develop web content for a company. Well, they paid you, so they own the copyright. You're hired to submit a business plan for a company or for an organization. That corporation, let's say, will own the copyright. You write your own blog and it's public, you own the copyright. So it really depends on who pays for the work. If you're in the software development, software are protected by copyright, which means that no one can copy the code and apply it to their own software. However, the functionality is not protected. So they could come up with different code doing the same thing. So it really depends on, so it depends how you protect it. Some people protect by patents when it comes to software, but it's a lot more complicated. And again, if any of you are in the software development, we can have a side discussion, but by and large, because patents get so long to get acquired and the chance that the source code will evolve rapidly, patents may not be the best option. Most of the time they rely on the trademark, on the reputation of the product. Okay, before I jump into IP services, any question on all the types we've seen? Because we're about 5 minutes to conclude the session. All right. So IP professional services are not, okay, this is separate from CIPO. These are all the patents and trademark agents. And it's very important when seeking professional assistance that you hire the right professional. I'm in Gatineau, but in Quebec, there's a lot of scam organizations that will pretend they will accompany you and protect you while they will not. So when in doubt, contact CIPO and it'll tell you if the firm or the individual you're hiring or planning to hire is legit. Because I've seen many people, many organizations losing a lot of money and efforts and losing their invention because they were badly accompanied. There's actually a recourse against an individual that was a scam company in Quebec. So it's pretty sad. So professional like patent agents, trademark agents will do the work that I will not do for you, meaning providing with an opinion on patentability, doing the search for you. Same for trademarks. We'll draft the application, we'll negotiate representing you. We'll make sure that the right that you've been granted, patent, trademarks, industrial design, you have the right to operate it, the freedom to operate opinion. And of course, they will make sure that if there's any infringement, they will support you and they will guide you through the actions you may take. So pretty much my role is to bring you to a point where you can either file on your own or you will be ready to hire an agent. What did you have to say about licensing about? Okay, copyright and licensing. Well, again, licensing a copyright is maximizing the value of your copyright on the market. So let's say an example, you wrote a book and it's a good success in libraries. And so a film producer will acquire the right to produce a movie on your book. So that's something about licensing your copyright. So, and in exchange of royalties, they will produce the film and distribute it in different countries. So all these steps will provide you with additional money on your book. I hope it answers your question, but it's literally licensing your copyright is ways and means to make money on the original work that you've created, be it a website, be it a software, a play, a music, etc. Pardon me. This slide explains the different services that SIPO offers for free. We have the Client Service Center that will help you guide you through the system, but also answer general question on IP. So if I have a name, is it a logo? Is it whatever, a copyright? And they will explain, yes, no, it's a trademark. If you file for IP protection, they will provide you with an update and a status on your application. They can help you find the appropriate form, finding a way, where to pay the fees, etc. So they will be like, I call it the technical aspect, and it's super important. As for my side, and an IP advisor, I do trainings such as this one, and we'll discuss together the strategic value of IP, how it can help you in your business endeavor, and how to create an IP strategy. And all these are for free. And it just happened yesterday that a client had some really specific question on trademarks, how to apply. So we connected with an information agent at the Client Service Center, and we spoke together for about an hour, and this person explained her in detail the mechanism to apply for a trademark. So it's time that you can spend and you can do the process on your own. Because you're in Ontario, these are my two colleagues, Dimitri is in Toronto and Alexis in Waterloo, and I'm in Ottawa, Gatineau, but also cover Northern Ontario. You'll have my email address, but more than welcome to reach out to me, and I'll connect you with if you want to reach out to Dimitri or Alexis, I'll put you in contact with them. If I use images in a book, okay, there's a question. If I use images in a book that I bought, or pages with typography and tear them out, is that a copyright infringement? Actually, yes. If you teared them out of a book, it's copyright infringement. We're not supposed to damage a copyrighted object. And if you publish those images, yes, of course, that's copyright infringement, unless you've got the consent of the copyright owner. So if you want, we can discuss that together, but there's a lot of gray areas when it comes to copyright. So that pretty much concludes. This is how to reach me. I have my email address. Client Service Center, very useful also. And you can follow SIPO on Twitter, LinkedIn, Facebook. And something else, a couple of months ago, we've launched a podcast. It's called Canadian IP Voices. Very interesting, different topics related to intellectual property. So yeah, that includes, if you are kind enough to fill the survey, it's fairly anonymous. I don't even see the results. So, and I welcome you. I'll send Brianna the PDF, so you will receive it, and you're more than welcome to reach out to me for more like specific discussion on your own projects. Any question before we wrap up?